My name is Maeve. I am 29 years old, and I was somewhere over central Georgia at 33,000 feet when I discovered exactly how thoroughly my husband had planned to destroy me. I helped a sick old man at my departure gate who simply called himself a retired judge who reads too many briefs. My husband Colin laughed when he saw that old man walk into the courthouse beside me. The laugh lasted about 4 seconds. Then the judge at the bench stood up so fast he nearly knocked over his microphone. Colin's attorney grabbed the table, and for the first time in our 6-year marriage, my husband had absolutely no idea what to say. Before I get into it, drop a comment and tell me where you're watching from. And if someone has ever mistaken your patience for weakness, hit that like button, because you'll understand exactly what I mean by the end of this. I was flying back to Atlanta after a systems security conference in Seattle when Colin's text arrived. We'd been separated for 19 days ever since he served me papers the morning after his company's IPO closed at $28 a share. I had been director of cybersecurity and digital infrastructure at TruePoint Technologies for 4 of the 6 years we were married. I had built the data architecture from the ground up. I had personally negotiated the contracts with 3 of their largest institutional clients. When the company went public, I wasn't in the office. I was at my mother's oncology appointment. The text read, "The settlement offer is $15,000. Sign it before the mediation tomorrow or my attorneys will make sure the judge sees the security logs from your unauthorized access of company servers. You hacked us, Maeve. Don't test me." I read it twice. Then I set my phone face down on the tray table and opened my laptop. I am a digital forensics specialist. My job, the one I'd had before TruePoint and the one I would have after, is finding things that powerful people are absolutely certain they have hidden. Deleted emails, metadata ghost prints on altered documents, transactions routed through shell entities to avoid reporting thresholds. When Colin wrote that I had hacked TruePoint servers, what he actually meant was that I had accessed the network drive using the credentials I had legally held for 4 years. Credentials that hadn't been revoked because, in his haste to get the divorce papers drawn up, he forgot I still had them. His mistake. I pulled up a file I'd been quietly building for 3 weeks, not out of suspicion at first, out of the same professional instinct that made me triple-check every system I'd ever been responsible for. And what I found in TruePoint's archived records made my chest go cold in a way that had nothing to do with recycled airplane air. 6 weeks before the IPO, Colin had transferred a block of core intellectual property, the proprietary encryption protocols I had personally developed during our 2nd year of marriage, to a Delaware LLC called Vanta Ridge Holdings. Vanta Ridge had no employees, no website, no physical address. It was a ghost company. The transfer had been executed using a technology assignment agreement. My signature was on the last page. I had never signed that document. I was staring at that forged signature, my jaw tight and my hands absolutely steady, when the man sitting across the aisle let out a sharp sound and slumped sideways in his seat. He was older, late 70s maybe, in a well-worn sport coat with reading glasses pushed up onto his forehead. A thick manila folder had been open in his lap. Now it was on the floor, pages fanning across the aisle, and he was pressing one hand to his chest with his eyes half closed. A flight attendant was 2 rows back. I flagged her before most people had even looked up. "He needs water and something with sugar," I said. "Now please." I crouched beside him and kept my voice even. "Sir, can you hear me? Can you tell me your name?" "Arthur," he managed. "Should have eaten at the gate." The attendant came back with orange juice and peanut butter crackers. I stayed with him while the color returned to his face and helped him gather the papers from the floor. His documents were dense, legal filings, circuit court level from what I could make out. I stacked them without reading and handed the folder back. He thanked me, and then he looked at me for a moment with the kind of attention that people give you when they are actually paying attention. "What were you working on?" he asked, nodding toward my laptop. "Something I need to figure out before tomorrow morning." "May I ask what kind of something?" I hesitated, but there was something in the way he waited, patient, unhurried, like a man who had spent decades listening to people who didn't know how to say what they meant, that made me tell him the truth. I explained what I did for a living. I explained what I'd found. I showed him on my screen the metadata anomalies in the technology assignment agreement. A creation timestamp 11 days after the date printed on the document, user credentials belonging to a paralegal at Collins' law firm, a digital certificate that didn't match the notary seal. Arthur put his reading glasses back on. He was quiet for almost a full minute. "You understand," he said finally, "that if this document was used to transfer intellectual property across state lines using fraudulent means, you're no longer looking at a civil divorce matter." "I know," I said. "Do you have an attorney?" I did. Collins' firm sent a letter to her last week, implying she'd be named in a sanctions motion if she continued to represent me. She withdrew. Arthur made a small sound that wasn't quite a sigh. "Where is the mediation?" "Peachtree Center, 9 in the morning." He nodded slowly. "I'd like to hear the rest of this. And I'd like to see those metadata logs if you're willing to share them." I looked at him. "You said you were a retired judge." "I did say that." "Retired from what exactly?" He almost smiled. "The 11th Circuit primarily, though I've kept busy since." I didn't ask what kept busy meant. I would find out soon enough. We landed at Hartsfield 40 minutes later. I had emailed him a read-only link to a secured copy of my evidence file before the wheels touched down. He gave me a business card with only his name and a phone number, no title, no firm. I tucked it into my jacket pocket. Then I walked out of the jet bridge and straight into the worst welcome home I could have imagined. She was standing near the baggage carousel in a cream blazer, holding a manila envelope with both hands like it was a bouquet. Colin's girlfriend, Tatum, 24 years old. She had been at the company holiday party last December in the exact same blazer and I'd complimented it. And she had smiled at me and said, "Thank you, Maeve." I'd had no idea. Around her neck was my mother's necklace. Not a similar necklace, not a piece that merely looked like it. My mother's antique pearl and diamond collar necklace, the one she had worn in her wedding portrait, in every Christmas photo I owned, in the last photograph taken of her alive. She had pressed it into my hands from her hospital bed 8 months ago and told me to keep it safe. I had noticed it missing 3 weeks after she passed. Colin had told me I must have misplaced it. He suggested I check my travel bags. Tatum was wearing it at baggage claim, and she was walking toward me with a smile that made my vision go briefly white at the edges. "Colin asked me to deliver these," she said, holding out the envelope. "He wants you to sign them tonight. He also wanted me to let you know that the $15,000 is final. There won't be a revised offer." She let the envelope drop when I didn't take it. "He also said," she tilted her head, dropping her voice just enough to still be audible to the couple standing 3 feet away, "that he feels terrible about how hard these last few years have been for you. The job pressure, not being able to start a family, all of it. He really just wants a clean start for both of you." I looked at her for a long moment, not at her face, at the necklace. "Where did you get that?" I said. Her hand went up automatically, fingers closing around the pearls. "Colin gave it to me. He said it was a vintage piece he found." "It's not vintage," I said. "It belonged to my mother. She died 8 months ago and left it to me. I filed a claim with my insurance company when it went missing. I'll be filing a police report tonight." The color left her face so quickly it was almost clinical. "I didn't know," she said. "Now you do." I picked the envelope up off the floor, tucked it under my arm and walked toward the exit. Arthur's car was waiting at the curb. He hadn't said it would be. He'd simply materialized beside me as I walked through the sliding doors, steadier on his feet than he'd been an hour ago, and gestured toward a dark sedan idling at the pickup lane. "I thought you might want a quiet ride," he said. "You look like you have work to do." He was not wrong. I spent the drive to my hotel with my laptop open and my portable hotspot running, building what I came to think of as the case file. I documented every piece of digital evidence in sequence. The creation timestamps on the fraudulent technology assignment, the IP transfer records linking Vanta Ridge Holdings to an account registered in Colin's personal name, the wire transfer records showing $2.2 million moved from TruePoint's pre-IPO escrow account to Vanta Ridge 3 weeks before the offering, and the piece that made my hands go still for a full 30 seconds. A draft email in TruePoint's archived outbox never sent, addressed to their outside counsel, that read, "If the forensics ever come back to M, we use the server access logs to establish unauthorized entry. She built the system, she knows how it works, make it look intentional." He had planned to use my own expertise against me. He had been building the setup for months. Arthur sat quietly and listened while I explained what I was finding. When I finished, he said, "Hash every file. You want to establish that the evidence predates tonight." I already knew how to do that. But the fact that he knew to say it told me something important about what kind of judge he had been. My hotel let me check in on my personal card without any issue. I had kept a separate personal checking account since my first job out of college. My grandmother had told me to, in the blunt way grandmothers of a certain generation say things that are actually financial advice. Colin had frozen our joint accounts, which was inconvenient but not devastating. I had anticipated he might. I was in my room by 9:30. I stayed up until 4. By the time I finished, I had a complete digital evidence package. The forged document with annotated metadata proof, the wire transfer trail through Vanta Ridge, the archived draft email, certified copies of the TruePoint IP filings showing the encryption protocols I had developed, and a chain of custody notation on every single exhibit. I printed 2 copies on the portable printer I'd packed, because I have been doing this kind of work long enough to know that digital evidence without a physical backup is a liability. At 7 the next morning, my phone buzzed with a voicemail from Colin. "I hope you got some sleep, Maeve. You're going to need it. The mediation starts at 9 and I strongly suggest you arrive ready to sign. My attorneys have already briefed the mediator. This is going to be simple, fast, and final. Don't embarrass yourself by making it into something it isn't." I listened to it once, then I texted Arthur ready. He replied, "See you at the mediation." Colin's attorney was named Everett. I'd met him at 2 TruePoint investor dinners and had found him deeply unpleasant on both occasions. He had the kind of confidence that comes not from competence but from never having been seriously challenged, and he wore it the way some men wear expensive watches, loudly and for other people's benefit. He and Colin were already in the conference room when I arrived, and Everett looked genuinely amused when I walked in alone and sat down across from them. "No attorney," he said. "Not today." Colin leaned back in his chair and glanced at my folder. "This doesn't have to be complicated," he said. "Take the check, move on." Everett placed a settlement agreement on the table and slid it toward me. $15,000 and a clean exit. "The 15,000, I said, doesn't account for the intellectual property that was transferred to Vanta Ridge Holdings using a document bearing a forged copy of my signature." The room went quiet. Everett recovered quickly. "Even if you have questions about a document," he said, folding his hands, "the evidence you're claiming to have was obtained by accessing TruePoint's proprietary network after your employment status became contested. That makes everything you pulled inadmissible. Fruit of the poisonous tree. I'll have your entire package excluded before you finish your first sentence in court tomorrow." He delivered it without drama, like a settled point of law. He was good. The door opened. Colin's mother, Gloria, swept in without knocking. She was a woman who had spent 30 years being the most powerful person in any room she entered, and she moved like she expected furniture to clear itself out of her way. "This ends right now," she said. "You sign that paper or I make a phone call to the president of the technology board that approved your last certification review. I have had lunch with that man twice this year." She placed her phone on the table like a weapon and sat down next to her son. I looked at her, then at Everett, then at the settlement papers. I stood up, collected my folder, and walked out. Arthur's text was waiting before I reached the elevator. "I reviewed the full file last night. There's something Everett doesn't know. Meet me at the coffee shop on Andrew Young Boulevard. I'll be there in 20 minutes. He was already at a corner table when I arrived, 2 cups of coffee waiting and a legal brief open in front of him. "Everett's suppression argument only holds," Arthur said without preamble, "if TruePoint had a reasonable expectation of privacy in the data you accessed. But you weren't accessing TruePoint servers directly. You were accessing a cloud backup synced through the home network, under joint administrative credentials that were never revoked. You were never removed from the access list." He turned the brief toward me. "More importantly, federal case law under the Stored Communications Act creates a specific exception when access data is being used to facilitate an ongoing wire fraud scheme across state lines. The privacy protection doesn't apply. It's been upheld twice at the circuit level." I read the highlighted passage twice. Everett argues family law, Arthur said. This is federal communications law, he's playing in the wrong jurisdiction. How do you know what Everett's strategy is going to be? Because I trained him, Arthur said simply. He clerked for me 26 years ago. I know exactly how he thinks when he's cornered. We spent 40 minutes at that table. By the time we stood to leave, I had the counter-argument memorized and every exhibit indexed by number, category, and source authentication. Arthur organized information the way a structural engineer organizes load-bearing walls. Nothing unnecessary, nothing misaligned, every piece exactly where it would do the most work. Outside the Fulton County Courthouse, Colin and Everett were standing near the entrance with Gloria and Tatum, talking loudly enough that the sound carried across the plaza. When Colin saw me approach, he said something to Everett, and they both laughed. When he saw Arthur, Colin's whole expression shifted into something openly contemptuous. "Did you seriously bring your grandfather to court?" he called across the plaza. Several bystanders turned to look. Arthur didn't break stride. He looked at Colin the way a person looks at traffic, registered, noted, continued on. He touched my elbow briefly as we climbed the steps. "Let him," he said quietly. "Arrogant men confess when they think they've already won." Courtroom 7B was wood-paneled and cool and smelled like old paper. I sat at the petitioner's table alone. Arthur took a seat in the front row of the gallery directly behind me. The Honorable Judge Warren Castellan entered at 10:04. He was a broad-shouldered man in his mid-50s with the particular impatience of judges who believe their time is being wasted before anyone has spoken. He looked at my table, noted the absence of an attorney's nameplate, and pursed his lips. "You're representing yourself?" he said before he'd fully sat down. "With an advisor, Your Honor." "Advisors are not." The wooden gate at the gallery partition swung open. Arthur walked through it. I have thought about what happened next many times, and I still cannot fully describe the moment. It wasn't dramatic the way movies are dramatic, it was quiet. Judge Castellan looked up from his bench, and something moved across his face. Recognition, then confusion, then comprehension, and then an expression that belonged to a man who had just understood that the one person in the state of Georgia, with the authority to end his career, had just sat down at the opposing table. Judge Castellan stood up. "Justice Calloway," he said. His voice was entirely different than it had been 10 seconds ago. I had no idea you were in Atlanta." In the gallery I heard Gloria say quietly, "Who?" Everett had gone the color of old plaster. Both hands were flat on the defense table, and he was staring at Arthur with the expression of a man watching his entire future rearrange itself into something unrecognizable. Arthur inclined his head with the patience of someone who has had rooms react to him this way before. "Judge Castellan, thank you for having me. I'd like to formally request permission to appear as pro hac vice legal advisor for the petitioner." "Of course," Judge Castellan said too quickly. "Of course, absolutely. The record will reflect that Justice Arthur Calloway of the 11th Circuit Court of Appeals has been recognized as legal advisor to the petitioner." Retired Justice Calloway, who had, after leaving the federal bench, accepted the chairmanship of the Georgia Commission on Judicial Conduct, the body responsible for investigating judicial misconduct and recommending removal from the bench. Everett knew this. He had known it from the moment Arthur stepped through that gate. He was still holding the table. Colin leaned over and hissed something at Everett. Everett did not answer. Arthur sat down beside me, placed his hands flat on the table and said, "I believe opposing counsel had a motion to file." Everett delivered his suppression argument. It was technically competent and completely joyless. A man reading from a script he no longer believed would work. In a voice that had lost its certainty somewhere around the moment, Arthur had crossed into the courtroom well. He argued that my access to TruePoint's cloud backup was unauthorized. He cited the fruit of the poisonous tree doctrine. He asked that my entire evidence package be excluded. He finished. The courtroom held its breath. I stood up. "Your Honor," I said, "opposing counsel's motion rests on the assumption that TruePoint had a protected privacy interest in the data I accessed. I'd like to submit a federal precedent that addresses exactly this situation." I walked the exhibit to the bailiff. Under the Stored Communications Act, and as upheld by the 11th Circuit in two separate rulings, The expectation of network privacy is extinguished when that network is being actively used to commit wire fraud across state lines. The data I accessed was stored on a shared home network under joint administrative credentials that were never revoked. I was not an unauthorized user, I was an authorized user who discovered an ongoing federal crime. Judge Castellan read the brief. He read it twice. He glanced at Arthur with the expression of a man who is acutely aware of being observed. The motion to suppress is denied, he said. The petitioner's evidence is admitted in full. Everett sat down and did not move for a long time. What followed was the deliberate, deeply satisfying process of watching 6 years of deception collapse under the weight of its own documentation. I took Colin through every exhibit. The fraudulent technology assignment, metadata showing creation 11 days after its stated date, user credentials belonging to a paralegal he'd brought on 3 months earlier, the wire transfer to Vanta Ridge, the pre-IPO escrow diversion, and the archived draft email. He tried to bluster. He tried to frame it as standard corporate restructuring. He tried at one point to argue that the encryption protocols were developed using TruePoint resources and therefore belonged to the company. Can you walk me through the date of first development on those protocols? I said. He hesitated. Because I can, I said. The initial version was written in a personal repository I created 14 months before I joined TruePoint, committed under my personal account with my personal email address. I have the commit history certified and notarized. Would you like to continue with that line? He would not. What broke him was the draft email. The one that said, if the forensics ever come back to M, we use the server access logs to establish unauthorized entry. She built the system, she knows how it works, make it look intentional. I read it into the record. I watched his jaw tighten. I watched him try to find somewhere to look that wasn't at me or at Arthur or at the judge. Did you write this email? I asked. Silence. Mr. Colin, Judge Castellan said, his voice flat and final, answer the question. It was a contingency plan, Colin said. His voice was fraying at the edges. Every company does strategic planning. This is completely out of context. You wrote an email instructing your outside counsel to frame me for unauthorized access, I said. As a contingency against being caught, you forged my signature on a legal document to transfer intellectual property I developed before your company existed. And you arranged all of this the same week I sat in a hospital with my dying mother. Something shifted in his face, the mask that wealthy, well-coached men wear, the one that says they've never once been wrong about anything, slipped. You don't know what it took to build that company, he said. His voice was climbing. You wrote code in a home office. I was the one in the room with the investors, taking the risk, taking the calls at 2 a.m. You want equity for writing code? You were compensated for writing code. Colin, Everett said very quietly. Everything that company became is because of me. He was leaning forward now, his face flushed. I'm sorry if that's a difficult thing to hear, but it's the truth. The architecture, the security framework, all of it. Those were tools I used to build something real. I deserved the value they created. I built something from nothing, and I was not about to hand half of it to someone who couldn't see what I was doing. The courtroom was utterly still. Judge Castellan set down his pen. Mr. Colin, he said, you have just testified under oath to the intentional misappropriation of intellectual property using a forged legal instrument and an interstate wire transfer. He paused. I'm stopping the proceeding here. He straightened in his chair very deliberately and did not look in Everett's direction at all. I am referring this matter to the U.S. Attorney's Office for the Northern District of Georgia for investigation of federal wire fraud and document forgery. I am issuing an immediate injunction on all assets associated with Vanta Ridge Holdings pending that investigation. I am awarding the petitioner full equitable interest in the intellectual property at dispute and full marital estate distribution to remedy the documented financial misconduct. He glanced down at the exhibit stack. I am also ordering an SEC referral for review of TruePoint's IPO filings. The gavel came down like a period at the end of a very long sentence. Gloria erupted from the gallery. She was on her feet before the sound had faded, pointing at the bench, her voice a register that made the court reporter flinch. The bailiff was moving toward her before she had finished her second sentence. She was escorted out, still talking, her voice echoing down the hallway outside until the heavy doors finally swallowed the sound. Everett closed his briefcase with the quiet, methodical movements of a man who has made a decision about his immediate future. He looked at Colin once. "I can't help you with federal charges," Everett said. "You understand that." He picked up his briefcase and walked out of the courtroom without looking back. Colin sat at the defense table and stared at the middle distance while the room emptied around him. In the hallway outside, Tatum was surrounded by people she didn't know. 2 officers had found her near the building exit. One of them was holding a small evidence bag. She surrendered the necklace without being asked twice. She pulled it off with shaking hands and placed it into the bag, and said "I didn't know" 3 times, to no one in particular. The officer brought it to me in the main lobby. I held it for a moment, the familiar weight of the pearls, the slight warmth from her skin still in the clasp, and then I fastened it around my neck and felt something release in my chest that had been locked tight for 8 months. When I turned around, Colin was being escorted out of a side door by 2 courthouse security officers. He saw me across 30 feet of marble floor. For just a moment, the arrogance was completely gone. He looked at me with something I hadn't seen from him in years. Not anger, not strategy, something worse for him. The expression of a man who has finally understood exactly what he threw away, 1 second too late to do anything about it. The door closed behind him. Arthur and I said goodbye on the courthouse steps in the mid-afternoon light. He pressed an envelope into my hands. Inside was a letter from the managing partner of a digital forensics and cybersecurity consultancy in Washington, D.C. One I knew by reputation, the kind of firm that federal agencies called when they needed someone who could find evidence that didn't want to be found. The letter was addressed to me by name. It referenced my background specifically. It used the word partner. "I made a phone call last night," Arthur said when I looked up at him. "After I finished reviewing your file. They've been looking for someone with your specific profile for about 8 months. I didn't have words adequate to the moment. "You didn't need me today," he said, and he meant it plainly, without performance. "You had the evidence. You had the legal argument. You had everything you needed before we ever landed." He adjusted his coat. "I simply made sure the room understood who it was dealing with." He shook my hand, and then he walked down the steps toward his car, leaning lightly on his cane, and that was that. I flew to Washington 3 weeks later. I packed 1 box from the house, books, my laptop, my grandmother's quilt, a framed photograph of my mother on her wedding day wearing the pearl necklace, smiling at someone just outside the frame. The necklace is around my neck as I write this. The SEC opened a formal investigation into TruePoint's IPO filing 6 weeks after the hearing. Vanta Ridge Holdings was dissolved by court order. Colin entered a plea negotiation on the federal charges. He had, after all, confessed to the substance of them in open court, in front of a retired federal appellate judge, with a court reporter taking down every word. Everett quietly withdrew from practice pending a state bar review. Gloria sent a certified letter through an attorney contesting the estate distribution. Her attorney withdrew 2 weeks later without explanation. Tatum sent me a short handwritten note. It said, "I am so sorry about your mother's necklace. I genuinely didn't know. I'm sorry for all of it. I kept it." There is a version of this story where I am defined by what Colin did. By the 6 years I spent building something that was never going to give back what I put in. By the forged signature, the stolen necklace, the $15,000 offer for work worth several million. By the morning he handed me papers instead of a phone call, while I was still in the parking garage of an oncology center. I don't tell that version, not because it isn't true, but because it ends in the wrong place. The truth is that I was 33,000 feet over central Georgia, exhausted and furious. When I closed my laptop and turned toward a stranger who needed orange juice and a few minutes of someone's attention, I didn't help him because I thought I'd get something in return. I helped him because he needed help and I was sitting right there. That's the whole reason. But here's what I know now, on the other side of all of it. The version of me who was trained to find what people hide found her own way out. Arthur opened a door, but I had already built the key. Colin bet against me at exactly the wrong moment. That's not my tragedy, that's his. If any part of this felt familiar, if you've ever done the work while someone else took the credit, or held yourself together in a room that was designed to make you fall apart, tell me about it in the comments. I'd really like to hear it. And if you want more stories like this one, subscribe. I'll be here.